Alrighty, hello everyone. We are falling a bit behind. I'm now in week 4 and I still haven't done week 2's video, so I'm going to try and do a bit of catch up today. In this week we're looking at sources of international law. So the main thing that we're going to be looking at is the Statute of the International Court of Justice. International Court of Justice, again, being a UN body. My browser's frozen, hopefully you can wake back up in a second. So the ICJ is a UN body, so if you sign to become a UN nation, then chances are the ICJ will apply to you. And it basically outlines in this statute that 4 sources of law are treaties, customs, general principles, and secondary source law. That's all the ones that are expressly mentioned in that article. Now, I got this text a bit wrong. If my browser was working, I'd edit it, but alas, it's not. So it's just judicial decisions and qualified publications, not soft law, that comes under the secondary sources. So for the first one, treaties. We jumped a bit ahead. Treaties we will look at next week, but they're basically any sort of agreement that is either writing or signed, that is in writing and signed. That's an agreement between 2 nations. I like to think of it kind of like a contract, but just in an international sense. Treaties can be closed or open. They can be between 2 parties or between as many parties as you like. And they can have different names. So they can be called conventions, they can be called agreements, they can be called, I'm sure they can have other names, so I just can't think of any at the top of my head. But yeah, that's what a treaty is, kind of like a contract between 1 or more countries. An international custom is something that 2 countries have been just doing forever. And because of that, because it's like habitual, it becomes part of law. So, for example, like this is, I don't think this is true. I've got no evidence to suggest it is true. But let's say that there was a case where India was trading 100 kilos worth of tea leaves to Australia, and Australia was exporting 100 kilos of wheat to India. And they've just been doing this for, there we go, we're back up and running. And they've just been doing this for centuries, right? And it's expected that that's just what's going to keep happening for the end of time. That would then become an international custom. Because both of them have done the general practice, and it's understood that both of them would want the other person to hold up their end, and therefore would want themselves to hold up their end. I know that didn't really make too much sense, but basically, like they both would have wanted that agreement to be legally enforced, so then that way they could keep benefiting from it. That desire for legal enforcement is called opinio juris, or opinio juri. I actually don't know how to pronounce these Latin terms, but so exhibit the general behaviour, so the trade, that's an objective test, and the intent, I'd imagine that's a subjective test, though I'm not too sure. Customs can be vetoed if a party never agreed from the start and made efforts to object to the customs. So we looked at a case, I forgot exactly what it was. I really hope we don't have to cite it, but it's, I'm going to get the facts wrong, and I'm sorry for European, but it's something like, imagine if we've got Norway up here, Finland here, and France here, right? It's something like Norway wanted their sea line of Finland to be flat all the way along their country, and Finland didn't want that, they wanted it to be more curved, but Norway and France were both like, yep, it's flat. But Finland, the whole time, they're like, no, we want it to be curved, we want to have a bit more space. And so Norway and France, they agreed, hey, yep, this is the custom, this is what we're going to do, and Finland was like, no way. If that's the case, and Finland vetoed it from the start, and if they tried to push against the custom, then the custom can't be enforced against Finland. I hope that sort of makes sense. So general principles are sort of gap fillers for when treaties and international customs fail. Usually they come from domestic law. They're like equity and good faith rules. Res judicata or a matter already judged comes into play here. Yep. So when these things fail, it will sort of default down to domestic law. I can't really think of any good examples of this, but the best sort of one I can think of is in contracts, looking at the CISG. And the rule in that is that if 2 parties are signed to the CISG, then both of them will be bound by the CISG. if one party is bound by the CISG and the other isn't, then the court will decide that whichever one is bound by the CISG, or whichever one has ratified it, the contract law will follow that country. So I'd assume that's the case where the ICJ would just say, okay, look, Australia and Taiwan, you both have your own laws. Australian law says this most aligns with our policy, so we're just going to go with Australian law. That seems to be what general principles are. Yeah, it could also be things like equity and good faith. That's right, so equity, if you don't know, like the three types of law in Australia are statute law, which is just whatever's written down. Then you've got common law, which is judge-made law, so in cases when judges make a decision, that becomes the law. And then there's equity, which is basically like you can do what's fair, what's quid pro quo, or you can do what's right. Equity law, for example, common law, for example, could be say, okay, you slapped me, you have to pay me $10,000. Equity law can say, you slapped me, you have to pay me $10,000, and you're not allowed within 100 meters of me. That's kind of like what equity is, and that's what general principles can cover as well. Under this principle, res judicata, or a matter already judged, comes into play. So, let's say under my Australia-India example, Australia goes, okay, well, you know what, I'm going to export 97 kilos of wheat instead of 100. And then it goes to court, and then the courts are like, whoa, no, Australia, you have to give 100 kilos. Australia then can't re-sue again and be like, no, I want to do 97. Right, once the matter's decided, it's decided. Unless, wait, no, never mind. So I was about to say something that comes up a bit later. Secondary sources include judicial decisions and teachings of qualified publicists. This is when all these fail, this sort of comes in. Article 51 of the Statute of the ICJ says that judicial decisions are not binding unless it's in the same case. So, in Australian law, if a judge decided something 400 years ago and the facts are the same, then you have to apply what the judge said back then to this case. That's not the same in international law. Unless we've got one case, and the case is sort of drawn out and there's multiple issues. And if right at the start a judge makes a decision here, that decision will still be binding for the rest of the case. So the judicial decision isn't binding unless it's in the same context of the same case. That's the rule there. But they can be used as secondary sources of law for other cases. Scholarly sources and qualified publications can be sources of law. So if we've got Barry, and Barry has been in the international law section forever, and he's been writing articles and doing journalist publications and doing all that kind of stuff, and he's like got many doctorates, and he's writing articles about what the law should be. Then because Barry's the most qualified, what he writes can become sources of law. So the source with the most qualifications. So if Barry's got 4 degrees and 4 PhDs, and Harry's got 3, then chances are Barry's gonna win it. All right, other sources of law. These are not listed in this little article up here. They're decisions from soft law. No, that's not right. Let me just touch that up. Actually, while I'm up here, I might just touch this up. And qualified publications. All right. Yeah. Okay. Law is soft law, international organisations, just Kogan's, and unilateral statements. So soft law is law that is pretty much just not enforceable. So I kind of think about it like international customs, where we've got an agreement, and that agreement works for a certain amount of time, but it's not legally binding. Let's say, let's pose an example here. Let's say we've got a couple of countries that are next to each other. Just trying to think of a country now. Okay, I'm gonna botch my geography a little bit, but let's say we've got Greece, a country in the middle. I'm going to say Switzerland, although I'm sure that's not true, and Italy, right? And they're all sort of in agreement. And Greece and Italy have a trade route, right? And they say, hey, Switzerland, can we just cut through your land and do the trade? And Switzerland goes, yeah, right, sure. And they didn't sign a treaty, they didn't do anything. It's kind of like a handshake agreement between two sort of international figures. That can become soft law. And it's it's sort of not legally binding. If Switzerland wanted to, they could be like, hey, get off my property, no trades here, or hey, enforce a tariff or whatever. But for the time being, that's just like with the agreement that we've got now, that's just soft law. And they could become hard law if the parties wanted it to. Like they could sign a treaty on it, or take it to court or whatever. But until then, it stays soft law. International bodies. So, for example, the International Civil Aviation Organization. They can have certain rules, and then if you're assigning to those rules, then you have to follow the rules. I kind of think of it like the Paris Conventions as well. Paris Agreement, got a name like that. Basically, a whole bunch of countries are like, hey guys, let's take a stand against climate change. So if you've signed that, then you have to follow the rules that entails. So that's international bodies. Just cogans means peremptory norms that supersede most international law. So for example, if Australia contracts Indonesia and says, hey Indonesia, we will give you 50,000 cows if you commit genocide. Well, that might be a treaty, and Indonesia might sign it, but just cogans would say, hey guys, genocide's kind of bad. Let's not do that, and then that would supersede the treaty. So yeah, same with torture, slavery, that kind of thing. Under just cogans, they are never justifiable in international law. Unilateral statements. So if you've seen the contracts video, you'd understand a unilateral statement is where I say something to no one in particular. I just kind of say it, and people can respond if they want. So Australia v France is a good case for this. So what was happening is France was doing some testings near Australia, near New Zealand, some nuclear testings, and Australia was like, whoa, hold on, we don't want that. And New Zealand actually said, we don't want that too. So this is Australia v France, New Zealand versus France, and same facts, same outcome. They were doing nuclear testings. Sure, Australia sued. France was like, hey, we don't want to go to the ICJ. The ICJ are not good enough for us. Boom. And so they couldn't really be sued. But then France made a unilateral statement saying, hey guys, we're going to stop doing nuclear testing near Australia. And so because they said that, that's a binding unilateral statement. Australia no longer had a case because France had said that they're just going to stop doing it. So that's what a unilateral statement is. It's a statement where my country says, hey guys, we are just not going to, we are never going to we're never going to start a war, right? And then that unilateral statement can become legally enforceable against the country that said it. Finally, Nicaragua versus the United States of America. There are a fair few facts in this case that I can't remember. But basically, if a rule is broken, instead of it being like, whoa, that's a pretty stupid rule, we declare that rule to be we declare the instance to be either like a broken rule or an exception to the rule, and it strengthens the rule instead of weakening it. It's the concept that the exception proves the rule. That's all I got for this video. Thank you for watching.